Thank goodness.
Thank
All right,
you.
good. Let's get back to a knife fight or something I can understand. All right. Did I interrupt your calling of the case, Mr. Clerk, or did you already call it? All right, good deal. You ready, Counselor?
Yes, Your Honor. May it please the court, good afternoon. Logan Davis for appellant Earl Maney. And with the court's permission, I would like to reserve 4 minutes for rebuttal.
Certainly.
Thank you. This case stems from a voluntary manslaughter conviction after a trial where defendant Mr. Earl Maney asserted a self-defense argument at the trial. I know Your Honors are familiar with the factual background asserted in the brief, so I won't spend time on that unless there's specific factual questions, and I'll devote my time to the two main issues. The general issues we addressed in the appeal are the improper lay witness testimony admitted at trial and the sentencing. At trial, the only eyewitness to the shooting was permitted over defense counsel's objection to opine to the jury that there was no threat at the moment of the shooting. We assert that this testimony is improper witness opinion testimony under Rule 701A and likely substantially influence the jury's verdict and prejudice the defendant.
Well, the state maintains that you have waived this issue or on that ground.
Respectfully, we disagree with that characterization.
So is it your contention that improper opinion testimony and objection based on that ground is the same thing as an objection based on speculation? And if it is, explain how, because speculation is rooted in Rule 601, whereas improper opinion is rooted in, what, 701?
Yes, Your Honor.
So could you please help me there?
Yes. So I think if in looking at the transcript and the record itself, the defense counsel appropriately alerted the court to the issue. He stated speculation, and he also stated going to the defendant's state of mind. There was an objection. The prosecution agreed to rephrase. The question was rephrased. Again, there was an objection that was stated, this is going to defendant's state of mind. And so we submit that this broad objection encompasses the 701 objection of improper witness opinion testimony, because it appropriately alerted the court and subsequent appellate courts to the nature of the issue.
So what rule is at play?
In this case, Rule 701,
Okay.
the improper opinion testimony. Yes, Judge?
Has to his state of mind, though, right?
Yes.
Okay, so when the trial court on strike 3, when the question was rephrased, the trial court actually participated a little bit, and I think I've got the question as, what did you see Mr. Rogers, and then the trial court's making its ruling clear, it said do as a threat at that time. So what he did, tell me specifically observations as to what he did has to do with what he was thinking.
And I believe the specific point that we would point to is the as a threat piece, because that piece is what requires the witness to insert his opinion. The testimony he provided previously provided the narration of events, orientation of where individuals were standing, who said what, appropriate observational testimony. And so the specific question, yes, it was phrased to what he saw, but it was as a threat. That required the leap, the step too far. And we assert that is improperly invading the jury's role.
So your objection really was to the use of the word threat.
As a threat.
Okay, as opposed to aggression, as opposed to just the open-ended question. Well, I guess I'm trying to see what the case law in this area talks about if allowing this type of testimony in the event there's no other way to explain it, for the witness to explain it. So the witness in this case, and forgive me if I misstated, they had walked him down explaining what was happening during this instance. I don't know what you want to call it. And so apparently state hadn't gotten what they wanted. Did you see what, so what I'm trying to get at is what else could the state what else are we looking at the state to have asked?
Your Honor, I think that's exactly it. I think the state did not elicit what they wanted, which was the witness, Mr. Nunley, to testify, inserting his opinion of the threat and replacing that of the defendant. I think the appropriate question is, what did you see happen next? And in terms of the case law, I think this case is distinguishable from the case law where the situations, the descriptions of what have taken place are inextricably linked. The witness is seemingly unable to describe the events without inserting opinion testimony, and the case law makes that clear that that's permissible. This is not the case here. The witness very clearly goes through the narrative and testifies as what he saw as the witness. And we would submit that just because the state did not get that final piece that they wanted, that is the improper piece.
So there was another case, I don't know if it was Cormio cited in your brief or the state's brief, that had a witness or was asked, inserted where threat is. In this case, self-defense was inserted in the other case. Did you see the victim act in, or did you believe the victim was acting in self-defense? Was there any behavior, and that case was upheld. So I'm trying to get the distinction for this particular case. Why is the word or the use of the word threat so damaging here with this witness's testimony?
Your Honor, what we would argue is that it does not have the necessity requirement as required by Blackburn in terms of what you were referring to. It's necessary for the witness's testimony and also impinges on the defendant's Fifth Amendment right against self-incrimination. And that is a more nuanced argument, I agree.
Very much so.
and a subtle argument, but we submit that that is what took place, and there is a burden shifting that took place where it is the jury in a self-defense case is required to, the self-defense argument has been fairly raised by the defense, and it is to be looked at through the perspective, the defendant's subjective belief. This testimony put forth before the jury put it so that they were looking at it through the witness's perspective, and that shifted the burden to where almost the defendant would be required to push back on that perspective.
Now this part of your argument was not raised below, correct?
Correct.
Okay. So
the Fifth Amendment claim was raised on the motion for a new trial.
But it
generally
was not preserved as an objection at trial.
Correct. But
you're deriving it from the 701 argument.
Yes, Your Honor.
Okay.
Yes, Your Honor. And I do believe it goes to the point of how it's important in this case, differentiating from the Cormier case that you were pointing to. And Your Honor, I believe I raised this, but just to point, we do believe that it was appropriately preserved in the record with the nature of the objection and the back and forth. Admittedly, it's not a pristine record back and forth, but the nature of the objection was raised. It was the trial court was alerted to that. To discuss a little bit further the Fifth Amendment concerns, the case law is clear that the defendant can assert a self-defense argument without testifying through circumstantial evidence. And that is exactly what was taking place here. And this testimony, as I said, impeded his ability to fully present that because it shifted the jury's perspective from his subjective belief to the witness's subjective belief and shifted the burden onto the defendant. And in fact, the trial court, in its order denying the motion for a new trial, which obviously is within the record, stated Mr. Maney had the opportunity to testify as to his own perception as to whether or not he was in danger of imminent danger of death or serious bodily injury, and thus give the jury his own perspective. We would submit, Your Honor, that is exactly the problem. That is not appropriate or permissible for that burden to be shifted onto Mr. Maney. We would also submit that this is not a harmless error at all. Mr. Nunley was the sole eyewitness to this shooting. The majority of this was captured on video footage, but the shooting itself was not, and Mr. Nunley was the sole witness. His statement directly goes to the core element of the case, which is the self-defense claim. And I would also point, Your Honors, to the fact that this was charged as first-degree murder. The conviction was for voluntary manslaughter. It's reasonable to infer this compromise verdict shows that some elements of the self-defense claim were accepted by the jury.
Or, as the state argues in their brief, the jury simply found there was adequate provocation to support the voluntary manslaughter, not necessarily that, not necessarily that there was self-defense involved here. So I guess, we can't really look behind what the jury was doing as the state's argument, and I'm not sure that I understand your harmless error argument.
Thank you. I'd like to turn now to the sentencing portion. And the issue, in this case, upon sentencing, the court imposed split confinement, including 11 months and 29 days of confinement. And the issue, there's several issues with that. The first is undervaluing the defendant's age and health conditions. The second is the reliance on the generalized deterrence statistics. And then the third was using Mr. Maney's continued self-defense claim as an aggravating factor in this case. The court acknowledged that Mr. Maney was a favorable candidate for alternative sentencing, and his eligibility for that was undisputed. The main point we would raise here is the internal inconsistency in the court's reasoning. The court recognizes that confinement would be, quote, a death sentence to Mr. Maney, and yet stated that it weighed this factor very little. I would put forth to this court that is internal inconsistency in the logic put forth by the court and not appropriately weighing this factor. And I'm not going to go through the litany of health issues that's all set out in the brief and the record, but I would submit to you all that Mr. Maney is an 87-year-old man with a litany of health issues that and the case law supports similarly situated individuals being granted home detention or something similar.
What was the date of the sentencing?
The date of the sentencing was August of 2022. I don't have the exact date in front of me.
So we're 3 years later.
Yes, Your Honor. So at the time.
And he's not dead?
He is not.
Okay.
Not yet.
Has he been on an appeal bond pending this, or has he already served his 1129, or?
He's been on an appeal bond, Your Honor.
Okay, that's what.
Yes, he was, subsequent to sentencing, he served 2 weeks in confinement, and then there has been an appeal bond ever since. And I would also point to, in our brief, we state that during that period, there were significant problems. This is not a speculative situation about what would happen to this individual upon confinement. He was not receiving appropriate medical care. He had significant health decline that is documented. In terms of the reliance on general deterrence, that was relied on as a factor at sentencing. The court relied on general statistics, broad statistics of an increase in violent crime. And we would submit to the court that there was no individualized assessment or case-specific nexus as to this type of case, this similarly situated defendant. In fact, the statistics show that homicides in that county had decreased. And so we feel that there was improper reliance put on using the statistics, the crime statistics, as that factor. And then finally at sentencing, the court pointed to the defendant's remorse and assessed the defendant's lack of remorse specifically because of the maintaining a self-defense posture. And we would submit that that's improper. The fact that the defendant maintained a self-defense posture, and as he is appealing the underlying case, should not be considered as an aggravating factor at sentencing. In fact, the case law supports the fact that that should be considered a mitigating factor at sentencing. And though a tragic outcome, the factors themselves do not outweigh the factors for an alternative sentence in this case.
I've read both briefs on this, and it is clear that the defendant has a multitude of health issues. The problem that I have, and you cited several cases where, pre-bias cases basically, where this court injected ourselves to address some of those concerns, not exactly the same as your client. The problem I have is that the trial courts have increased discretion now, and there has to be some palpable, abuse of discretion to overcome what we're required, our constraints on appellate review of sentencing. And can you help me understand what error the trial court made to allow us to overcome the presumption of reasonableness and that this sentence is entitled to? Does that make sense what I'm saying?
It does, Your Honor. And I think what I would point to is the internal logical inconsistencies, because the presumption of reasonableness rests on the principles being followed logically. And so I think the internal inconsistencies in the reasoning given by the court allows that decision to be overturned.
Okay. And if I may ask one other question.
No, certainly.
So I'm going to just return just for a moment to the 701 argument. What is troubling to me about the rule in this area of the law is, in this case, it was almost as if this was just one question too many. The state had already seemingly asked every question they could ask of what you observed. Was the victim doing anything? Did he have anything in his hands? I don't know if those were the exact questions. But so walking the witness down the narrative of everything they observed, which clearly satisfies the first prong of the rule. That last question, did you see any threat? Did you see the victim, I guess, engage in threatening behavior? I don't know if that's the exact phraseology, but the use of the word threat. Even if that was improper, why doesn't the prior questions and the witness's prior observations, why don't they negate that use of the word threat? Does that question make sense? Because you already had the testimony that the witness did not observe the victim engaged doing anything. So I guess if I agree with you that the rule was improperly applied in this case, I'm trying to look at what was the harm. And I know you said this was the only eyewitness, but the witness didn't say anything, in my mind, inconsistent with what he already said prior to the state's use of the word threat. Does that make sense?
It does.
And it goes counter to the second prong of the rule, that this witness was trying to replace his opinion testimony and just tell the jury the right answer as opposed to what he observed. Does that make sense?
I believe I understand,
Okay.
if I may attempt.
Yes, please.
And I think the crux of it is the previous questions are appropriate and show the circumstances, even if it is just one question too many and one question improperly asked. That is enough to shift from observation to opinion and shift from observing a scene in front of you to injecting the perspective that takes away the perspective from the defendant in terms of asserting the self-defense argument. And so I think it's really a shift from observation to inserting opinion.
Thank you.
If you have no further questions, I'll reserve the remaining 20 seconds for rebuttal.
Certainly. We'll give you a little extra time if you need it for rebuttal, but we ask a lot of questions. Good questions, excellent questions. General.
May it please the court, Catherine Redding on behalf of the state. The defendant is not entitled to relief on his claims regarding Mr. Nunley's testimony. It's the state's position that the defendant is only entitled to plain error review because he did not raise these claims below. I mean, defendant has conceded that certainly I believe the defendant. I don't want to speak out of turn. I can't remember whether defendant conceded that he did not object to the testimony infringing on his right to remain silent. But in any event, the state's position is that these two claims, that it was improper opinion testimony and that it infringed on his right to remain silent, it's the state's position that those are only reviewable for plain error because the objection in the trial court was limited to speculation. I think that it starts out with an explicit speculation objection and it continues and the court tries to get the state to reframe the question. And when what we have is this final question, what did you see Mr. Rogers do as a threat at that time? And Mr. Nunley answered, I didn't see any threat at that time. And so if the defendant's position is that the word threat, saying I didn't see a threat, constitutes an opinion, that needs to be clear because it is not clear that that is what the objection was in the trial court and that the trial court understood the objection to be based on opinion rather than speculation. And I'd say that given that the defendant hasn't, and I certainly don't see anything here about violation of the Fifth Amendment right to remain silent. So if this defendant did not object based on those grounds below, then the only relief he's entitled to is plain error relief, but you have to request plain error review, and certainly the defendant has not requested plain error review and is instead kind of stood on the position that a plenary review is appropriate. But given that the state's position is that plain error review is the only review available, I will proceed with making that argument. And I'd say that first, this court has a long history of declining to consider evidentiary issues under plain error review based on its conclusions that that doesn't generally involve substantial rights. I think that's a little bit different given that the right to remain silent is a substantial right, so I don't think that that would necessarily apply to that particular claim that the defendant's raising. But perhaps more strongly is the defendant's failure to show the breach of a clear and unequivocal rule of law. Now, if we go to the opinion testimony question, it's the state's position that the testimony that Mr. Nunley offered, I didn't see any threat at that time, does not constitute improper opinion testimony. It's rationally based on perceptions in that he was testifying about the incident and any threat that the victim posed based on his firsthand experience of the incident. His testimony helped determine a fact at issue, whether the defendant posed a threat to the defendant. His statement, I didn't see any threat to the defendant at that time, summarized, essentially was a summary of what he had just said.
Would it have made a difference if he said it voluntarily as opposed to the state asking?
I think procedure, we'd have to come at it differently. I think then we would be talking about mistrial, and I don't.
My problem is the use of the word threat.
Right.
And the state's injection of the word threat, as opposed to a witness who is, as he had done, he was expressing what he observed at the time. And then that question pertaining to the threat, and I know the exchange, they were trying, the prosecution offered, I'm asking Mr. Nunley to describe a physical phenomenon that was before him and within his eyesight. I don't know that it was necessary for the prosecution to use the word threat in order to get their point across if the witness had already said the victim wasn't doing anything.
I think that this question can be understood as the state trying to ask, did you see any threatening behavior? And I don't think that that asks for or elicited improper opinion testimony. I think it certainly would be different if the state said, now, if you were in the defendant's shoes and this happened, would you feel that you were being threatened? Or did you think the defendant felt threatened? Do you think it's reasonable for the defendant to have felt threatened? And certainly that would be, I think we would be having a different conversation today. But I think that even still, the question of what did you see him do as a threat? Do as a threat is, I think, an artful, what threatening actions did you see? And that's asking for it's asking for testimony based on perceptions. It's not well, let me do some internal calculus, and if I had seen this, how would I feel and how would I respond? So I just think that given the question and the phrasing, despite the inartfulness, I think given the question and given what Mr. Nunley said, I didn't see any threat at that time, don't think that that is opinion testimony. And as to the claim that testimony infringed on the defendant's right to remain silent, I just don't think that the record supports that claim. Mr. Nunley did not comment on the defendant's right to remain silent. The state certainly did not with its questions. There's no indication that Mr. Nunley in the statement was attempting to testify on behalf of the defendant, that he speculated about the defendant's state of mind. I did not see is different, very different from kind of cases we see where the defendant's right to remain silent is infringed upon. And then there's just no indication that Mr. Nunley was imputing knowledge to the defendant or about the defendant. And for these reasons, the defendant can't show a substantial right was adversely affected, that the trial court breached a clear and unequivocal rule of law, or that consideration of the error is necessary to do substantial justice. And I think that actually takes to your point, Judge McMillan, is that this is the last question in the line of questions, and it's kind of a summary question. So if you already have all of this information that's come in, where is the harm in this final question when it is not opinion testimony and doesn't infringe on the right to remain silent? As to the defendant's sentencing claim, the trial court acted within its broad discretion when it imposed a sentence of split confinement. The trial court reviewed the evidence, the circumstances of the offense, the sentencing memorandum, the defendant's age and allocution, the victim impact statements, the risk and needs assessment, the enhancement and mitigating factors, the violent crime statistics, and the relevant sentencing statistics, and it concluded that a short period of confinement was necessary to avoid depreciating the seriousness of the offense and to deter others. And the record supports the trial court's conclusion. Because the trial court did all of these things, it imposed a within-range sentence. It's entitled to review for abuse of discretion, as this court has noted. And the record supports the conclusion that a short period of confinement is necessary to avoid depreciating the seriousness of the offense. This is a defendant who shot the victim when, according to Mr. Nunley's testimony, there was no threat. We know this from the evidence. The defendant had multiple seconds to reflect before he pulled the trigger, but chose to kill the victim despite that opportunity to refrain. The defendant had gone to these tenants' businesses either intending to inflict harm or at least expecting he might use his weapon. There was testimony from Mr. Nunley that he had a weapon that he regularly carried for self-defense, but on this occasion he took a larger gun with him. The defendant threatened Mr. Fowler and held him at gunpoint before he shot the victim, displaying little concern for the lives of others. And the trial court found, as it was permitted to do so, that the defendant was not remorseful when he reiterated at sentencing that he had acted within his rights in shooting the victim and said, "I did what I had to do to survive." The defendant never admitted fault or expressed that he acted wrongfully, and the trial court was in the best position to hear the defendant's statements and make a conclusion about what that meant in terms of the defendant's remorsefulness. The record also supports the conclusion that a short period of confinement was necessary to deter others from committing similar acts. There was evidence presented at the sentencing hearing about general homicide statistics in Tennessee, generally increasing over the past several years, and about homicides specific to Cleveland, Tennessee, that had generally increased over the past 4 years. The statistics that were submitted by the state confirm this detective's account, and I don't think that there's no requirement under the law that the statistics be so specific as to the defendant. We're not required, the trial court's not required to find, we have a rash of 82-year-old business owners killing visitors to their tenants' properties. It doesn't require that much. It's general information about general homicide numbers in Tennessee, and then numbers specific to the community in which this crime occurred are more than sufficient for a deterrence finding. The defendant's not entitled to relief on his claim that the court should have recognized his claim of self-defense as a mitigating factor. The court pointed out that the jury's verdict of voluntary manslaughter doesn't necessarily mean that the jury found the self-defense claim credible. It simply means it found the state did not prove the elements of the greater offenses and instead found that the state had only proved voluntary manslaughter. The defendant is, again, not entitled to relief on the claim that the trial court failed to give adequate weight to his health issues. Certainly, he does have extensive health issues, but the trial court considered his health, appeared to credit it as a mitigating concern, but found that it only slightly weighed in his favor. And mere disagreement with the weight that is given to mitigating factors is not a basis for appeal. And that is really what the defendant's claim boils down to, is that he has a lot of health issues, and the trial court just didn't give those enough weight. And that is under Bice and the Bice progeny, it's not a basis for appeal. And I'll just point out again that this case is distinguishable from Poston, which is an unpublished pre-Bice case. We're here under a different standard of review. The defendant here did not have a credible claim of self-defense. Mr. Poston's health problems, although the defendants are severe, Mr. Poston's were more severe, and the trial court in Poston misapplied the confinement factor it relied on to deny alternative sentencing, and that is certainly not the case here. And the defendant kind of touched briefly on the defendant's decline since sentencing and what's happened, and that is, I guess, more of a challenge to the denial of the motion to reconsider sentencing, and that claim is just not properly before this court because we have an inadequate record. We don't have the documents that the trial court relied on. It's not, I'd say it's kind of tucked into the defendant's sentencing argument, but isn't its own, identified in the statement of the issues, kind of fully briefed. And so because there's an inadequate record, I think the court can end its any analysis there. But even if this court were to get into what we do have, I think that the defendant just simply hasn't shown that the trial court conducted an improper weighing of the information that it had before it. So if there are no further questions.
If this defendant's position from the very beginning was that he shot this other guy in self-defense, and he sticks to that position, and at the sentencing hearing, I can't remember if he probably testified. I don't know if he testified or not, but if his position is, I shot this guy in self-defense because otherwise, that's what self-defense is. I would have been killed otherwise. Is it fair to say, well, you don't have any remorse?
I don't think that would be, I'd say first, I don't think that is the case here. I think that the defendant's statement made, not a lengthy statement, but he said a few more things, and the trial court was in the best position to kind of observe his demeanor and kind of, obviously the trial court observed the defendant, heard the statement, and was in the best position to draw a conclusion about what the remorse was. I think that if the defendant had simply maintained from the beginning and then insisted on standing on his innocence, that we would be in a
No,
position.
it's probably more complicated than but I just seemed to me, if you're going to stick by your self-defense theory and all of a sudden you're convicted by a jury, not all of a sudden, it probably took at least a day or two, but, and then I don't think I'm not sure it's fair for them to have a defendant say, well, since I got convicted, the jury was right, I was wrong, I
Right.
feel terrible, I shouldn't have shot the guy.
Right.
You see what I'm saying?
I do, and
Yeah.
I think that we see that come up in kind of diversion, version probation situations where we have statements that are given to counselors and other people where they, stand
know
on their
that's just
position
one-
that they had
that's just-
before. But I think, and certainly in a case where a trial court would somehow deny alternative sentencing based solely on a defendant's lack of remorse, that would certainly be an issue.
Right.
But here, given that the trial court denied it based on the circumstance of the offense and the need to deter, I think that,
There's a lot of factors, I know,
Yes.
in her decision
and,
on the sentencing.
and I think that those two are really what drive the decision and what support the trial court's determination that a short period of confinement was appropriate given what occurred in this case. If there are no further questions, the state asks this court to affirm.
Thank you, General.
I don't have anything further to add. I would just ask that the court reverse and remand to the trial court for a new trial or any alternative for resentencing. But thank you for your time.
I was counting on you using a little time so I could get the top off this water.
Well, I apologize for
Could you-
disappointing.
I do want to say how well prepared both sides were and well argued, and we appreciate that. We hear a lot of cases, and sometimes they aren't as well argued, and sometimes the lawyers aren't as well prepared. So we really do appreciate it. It helps us do a better job. It didn't help me get the lid off, but somehow I did anyway. So, all right. Thank you very much. Anything else for today? No, sir. All right, thank you. We're in recess till, and I know the date, it's December 18th, right? All right.